Well, violent crimes committed by people claiming mental illness grab headlines, but cases where the accused is truly mentally ill tend to be rare. Still, they do happen, and when they do, local law enforcement and the court system have to take some extra steps to make sure justice is served. Our Riley Livingston takes a look at how they handle these cases. She joins us live in Columbus with more.
Andrea, here at the Lowndes County Courthouse, every court term is different and every case is different. But when it comes to mental competency, there is a definite set of procedures that have to be followed. According to mentalhealth.gov, only 3 to 5% of violent acts are committed by people with serious mental illness. But when those crimes are committed, law enforcement steps in.
If they're charged with a felony and there is reasonable belief that someone has a mental illness that affects their ability to consult with us, then we file a motion for a mental evaluation with the court. Typically, the court will simply go ahead and sign an order based on our belief that our client is incapable of speaking with us or conferring with us to assess their defense and prepare their defense.
That evaluation takes time.
In the past, we had one forensic psychiatrist in the state. He had covered 82 counties. It took years to get people to mental evaluations, and in the meantime, they were incarcerated because nobody knows if they're a danger to themselves or others. Recently, the state has hired some more forensic psychiatrists. Their docket is moving faster. They're getting to the evaluations within a matter of months now.
Smith says after the defendant has that evaluation, they are declared either competent or incompetent to stand trial. If they are incompetent, then they are committed to the state mental hospital to restore them to competency, but sometimes that never happens.
If at the end of 3 to 4 mental evaluations, the defendant is still considered incompetent to stand trial, the circuit court is then going to order the DA to dismiss the charges and bring that defendant into chancery court to be committed. The commitment's for 90 days. It's not much help.
But Smith says charges don't always have to be the first step for law enforcement.
I actually like to see mental evaluations before they charge someone, and there is a provision in the law for that. If they get those mental evals and they realize someone is mentally ill, then they should be placed in a community mental health facility.
Smith says a person who already has a mental illness diagnosis usually goes through the same procedures as somebody who does not have that prior diagnosis. Reporting live in Columbus, Riley Livingston, WCBI News.